All right, let's get ready to unpack some South African law. Today we're taking a deep dive into estoppel and enrichment.
Two concepts that are sometimes a bit tricky.
Yeah, a little tricky, but super important when it comes to fairness in legal matters, right?
Exactly. It's all about keeping those scales of justice, balanced.
Okay, so to help us break it all down, we've got some legal excerpts and a few study guides with us. Think of this deep dive as your shortcut to understanding how these legal principles actually play out in real-life situations, how they can impact you.
Yeah, they can impact you directly.
So let's start with estoppel. In our study guide, estoppel is actually described as um, a doctrine that prevents someone from, well, basically from going back on their word when it would be unfair
Yeah,
to do so.
right.
And they use the example of a partnership where one partner resigns, but a supplier who's unaware of the change continues to extend credit to the partnership based on the reputation of the former partner.
It's a classic case of someone relying on a situation, that's no longer true. The supplier was led to believe the former partner was still, part of the picture.
Right. And that reliance is key. So in this scenario, the study guide actually asks us to consider whether the former partner can actually be held liable for those debts that were incurred after they left.
Okay.
What do you think?
Well, it hinges on whether the supplier's reliance was reasonable and if the former partner acted in a way that, contributed to the misunderstanding.
So if the former partner didn't inform the supplier that they were leaving, or even actively created the impression that they were still involved,
Yeah,
then estoppel might kick in.
exactly. Estoppel is all about preventing injustice. It would be unfair to, allow the former partner to just escape liability if their actions directly led to the supplier's losses.
Okay, let's get into the nitty-gritty of estoppel. One of the legal excerpts actually quotes Judge Curlewis, who described estoppel in Pays. He says it's basically about preventing someone from benefiting from their own bad faith. And our study guide connects this back to Roman law with the concept of exceptio dodi mali,
Wow.
which basically says the same thing.
Interesting.
Isn't that fascinating?
Yeah, it just shows that this principle of preventing someone from profiting from, deceptive actions, it has deep roots.
Yeah, deep roots.
Yeah, in legal history.
So how does this ancient legal wisdom apply today?
Well, to understand how estoppel actually works in modern law, we need to kind of break it down
Okay,
into its key elements. Think of it like a checklist.
all right, checklist, I like it.
First, you need a misrepresentation. Someone saying or doing something that creates a false impression.
Okay, so using our partnership example, that misrepresentation could be the former partner failing to inform the supplier that they're resigning, or even continuing to act as if they were still a partner.
Exactly. And
Yeah.
that sets the stage for the next element.
Okay.
Reliance. The person claiming estoppel has to show that they relied on that misrepresentation.
So the supplier believed that the former partner was still part of the deal and continued to extend credit based on that belief. Makes
Right.
sense.
And that reliance must be reasonable.
Okay.
Would a reasonable person in the supplier's position have acted the same way?
So the supplier can't just blindly trust anything they hear. They need to exercise some due diligence.
Absolutely.
Okay.
Now, the next element is prejudice.
Okay.
The person claiming estoppel has to demonstrate that they suffered a detriment
Okay.
because of their reliance on the misrepresentation.
So in our case, the supplier extended credit that they wouldn't have otherwise.
Yeah.
And now they're facing losses because the partnership can't pay up.
Right.
That's a clear prejudice.
Precisely. Now, there's also the element or fault, but South African law doesn't always require it for estoppel to apply.
That's interesting. It seems counterintuitive that someone could be held liable even if they didn't intentionally misrepresent something.
Well, the law recognizes that even unintentional misrepresentations can lead to unfair outcomes. It's about protecting the party who relied on that information.
Okay, I see the logic there. So we've got our checklist for estoppel,
Yeah.
misrepresentation,
Uh-huh.
reliance, prejudice, and sometimes fault.
Right.
But can estoppel be used to validate something that's actually invalid? like an act that's ultra vires. The study guide dives into this a bit, using the example of a clerk mistakenly issuing a trade license.
Oh, that's a great question. And the shite answer is no.
I know.
Estoppel can't override the law. It can't magically transform an illegal act or an unauthorized act into a legal one.
So even if the recipient of that mistakenly issued license acted, in good faith and relied on it to start their business,
Yeah.
the estoppel wouldn't protect them.
Unfortunately not. The courts would likely rule that the license was invalid from the start, and the recipient would be in a tough spot. It highlights the limits of estoppel.
Yeah. So it's not a get out of jail free card.
Exactly.
Yeah, I think we've laid a solid foundation for understanding estoppel. Now, the study guide, it actually poses some additional scenarios to test our understanding of this concept. One example involves a void lease agreement.
Ah, yes. The case of someone occupying a property based on a lease that turns out to be invalid.
Right.
It raises the question of whether the landlord can simply evict them, or if estoppel might come into play.
It's tricky.
Yeah,
It is.
it is.
On the one hand, the lease is invalid,
Right.
but on the other hand, the occupier might have relied on it
Yeah.
to their detriment. Maybe they even invested in the property.
Exactly. To unpack that scenario, you'd have to look at whether the occupier was even aware of the lease's invalidity, whether the landlord somehow contributed to the misunderstanding, and whether the occupier suffered any prejudice.
There's no easy answer.
No.
It's a case-by-case assessment.
Definitely.
Okay, let's move on to another scenario from the study guide. A countermanded check. So someone issues the check and then stops payment on it, but the recipient has already acted in reliance on that check.
This is where things get really interesting.
Yeah.
Yeah, it touches on the concept of the time at which the misrepresentation is considered to have taken place.
Okay.
In this case, you have to ask, when did the misrepresentation actually occur? Was it at the time the check was issued, or at the time it was presented for payment?
So the court would need to determine which point in time is relevant for establishing, reliance and prejudice.
Precisely. It highlights the importance of, pinpointing that exact moment
Okay.
when the misrepresentation actually becomes actionable.
All right. I think we've thoroughly dissected estoppel.
Yeah.
Ready to move on to enrichment?
Absolutely. Let's explore those situations where someone benefits unfairly at another's expense.
Okay, let's dive into this world of unjustified enrichment.
Okay.
The study guide kind of lays out the basic idea. One person becomes richer at the expense of another without a valid legal reason.
It's like getting a free lunch, but instead of someone else paying for it, they're actually footing the bill without even knowing it.
Right, and the law steps in to correct that imbalance. Our study guide uses a classic example: someone mistakenly painting the wrong house.
Oh yeah.
The homeowner gets a brand new paint job they didn't pay for, while the painter is out the cost of materials and labor.
That scenario perfectly captures the essence of of unjustified enrichment. You have one party benefiting and another party suffering a corresponding loss without any legal justification.
Okay, so how do we determine if someone is liable for enrichment? What are the criteria?
The study guide outlines 4 key requirements:
Okay.
enrichment, impoverishment, sine causa, which means without legal cause, and causality. It's important to establish all 4 to make a successful claim.
Okay, let's break those down. What exactly constitutes enrichment in a legal sense?
Enrichment means the defendant, the person accused of being unjustly enriched, has experienced a measurable increase in their assets or a decrease in their liabilities. In our house painting example, the homeowner's property value increases because of the free paint job representing enrichment.
Got it. So there needs to be a tangible benefit for the defendant. What about impoverishment?
Impoverishment means the plaintiff, the one claiming they were wronged, has suffered a corresponding decrease in their assets or an increase in their liabilities.
So the painter in our example has experienced a financial loss because because they used their own paint and labor on a job they were paid for.
Exactly. But remember, impoverishment isn't always about direct financial loss.
Okay.
It can also include a missed opportunity to gain something.
Ah, I see. So even if the painter hadn't bought the paint yet, they've still lost potential income because they could have been working on a paid job instead.
Precisely. The law recognizes the value of lost opportunities when assessing impoverishment.
Okay. Two elements down, two to go. What about sine causa?
Sine causa, meaning without legal cause, is crucial. It means there's no valid legal basis for the enrichment. The defendant shouldn't have received the benefit in the first place.
So in our painting mishap, there's no contract, no agreement, no reason for the homeowner to receive that free paint job. It was a pure mistake.
Exactly. And if there was a valid contract for the paint job, then there wouldn't be a case for unjustified enrichment.
Right, because the homeowner would be entitled to the paint job. Okay, last element, causality. What role does causality play in enrichment cases?
Causality means demonstrating a direct link between the enrichment and the impoverishment. We need to prove that the defendant's gain is a direct result of the plaintiff's loss.
So in our example, the homeowner's shiny new paint job is directly linked to the painter's expenses and lost income.
Yes,
If those costs weren't incurred, the homeowner wouldn't have received the benefit.
exactly.
Okay.
It's a chain reaction. One action leads directly to another. Without that clear connection, it becomes much harder to establish unjustified enrichment.
Okay, so we've got our four key ingredients: enrichment, impoverishment,
Right.
sine causa, and causality. Now, the study guide dives into specific types of enrichment actions, starting with the Condictio indebiti. What exactly is that?
The Condictio indebiti is all about reclaiming something that was transferred by mistake. Think of it as a legal indo button for payments or transfers made in error.
So if you accidentally send money to the wrong person
Yeah,
or pay a bill twice, you could potentially use the Condictio indebiti to get your money back.
precisely. But there's a catch.
Oh,
You have to prove that the payment was made due to a justifiable mistake.
so you can't just claim a mistake if you simply changed your mind about a payment or made a careless error.
Exactly. The study guide dives into the concept of error in some detail. The courts have held that the mistake must be reasonable and excusable. It shouldn't be due to gross negligence or recklessness.
So accidentally typing in the wrong account number when making an online transfer would likely be considered a reasonable mistake.
Yeah.
But just throwing money around without any care or attention to who you're paying would not.
Precisely. The law aims to protect those who make genuine mistakes,
Yeah.
not those who act carelessly.
Okay. The study guide highlights the Willis-Faber-Enthoven case, emphasizing the importance of proving a reasonable error for a Condictio indebiti claim to actually succeed. What happened in that case?
In the Duress-Faber-Enthoven case, the plaintiff made a payment they believed was due under a reinsurance agreement. Later, they discovered the payment wasn't actually necessary,
Oh,
and they sought to reclaim it using the Condictio indebiti.
right.
However, the court rejected their claim because they couldn't demonstrate a justifiable error.
Hmm.
They had access to the correct information all along, but failed to properly interpret it.
So that case established a precedent for requiring genuine, excusable mistakes in Conditio and indebiti claims. What about those situations where someone knows a payment isn't due but makes it anyway, can they still reclaim it using the Condictio indebiti?
That's where things get a little more complex.
Uh-oh.
Generally, if you knowingly make a payment you don't owe, you're out of luck.
Okay.
However, there are some exceptions.
Okay. Give me an example of when a claim might be successful, even if the payment was made knowingly.
Well, imagine a situation where someone is threatened with harm or legal action if they don't make a payment, even though they know they don't owe the money. They might they might feel compelled to pay under duress.
Hmm.
In such cases, the condictio and indebiti could potentially be used to reclaim the payment.
So the law recognizes that sometimes people make payments under pressure, even when they know it's not strictly required. Are there other instances where knowing payments might be recoverable?
Yes, another example is when a payment is made to protect the interests of a third party. You might know you don't personally owe the money, but you pay it to prevent harm to someone else. In these situations, the court might be more lenient in allowing a claim for recovery.
It sounds like the court assesses these cases on their individual merits, taking all factors into account.
Exactly. The goal is to ensure fairness and prevent exploitation, even in situations where the traditional rules of the Condictio indebiti might not apply.
Okay. The study guide then dives into some specific applications of the Condictio indebiti.
Yeah.
One that jumps out is payments made under duress. Can you expand on that a bit?
Absolutely. We touched upon this briefly. Duress in this context refers to situations where someone is forced or coerced into making a payment against their will. It could involve, threats of violence, legal action, or damage to reputation.
So if someone is forced to pay a bribe to protect their business interests, they could potentially use the Condictio indebiti to recover that money.
Potentially, yes. However, proving duress can be tricky. The plaintiff would need to demonstrate that the threat was real and immediate, and that they had no reasonable alternative but to make the payment. The court would scrutinize the specific circumstances very carefully.
Right. So simply feeling pressured wouldn't be enough. There needs to be a genuine threat that compels the payment. What other scenarios fall under the umbrella of the Conditio indebiti?
Another important application is in the context of statutory enrichment actions. These are specific types of claims created by law to address unique situations. One example is claims involving deceased estates.
Okay, so imagine a situation where someone dies, and their estate has already been distributed to the heirs.
Yeah.
But then a creditor emerges with a valid claim that was overlooked during the initial beneficiation process. What happens then?
That's where these statutory enrichment actions come in. The study guide outlines a specific process for handling such claims. It involves notifying the executor of the estate, proving the validity of the debt, and potentially recovering the funds from the beneficiaries who received the inheritance.
So it acts as a safety net to ensure that creditors aren't left high and dry, even if their claims are initially missed.
Exactly. It's all about striking a balance between the rights of creditors and the interests of beneficiaries in deceased estates.
Okay, we've covered a lot of ground with the Condictio indebiti, but the study guide goes on to explore other types of enrichment actions. What else awaits us in this legal landscape?
Well, there are a few more key acronyms to unpack. Each one addresses a different type of scenario where unjustified enrichment might occur. So we've got the Conditio indebiti, our legal undo button for mistaken payments. But it sounds like there's a whole family of these enrichment actions, right? Each one designed to address a unique scenario.
That's what our study guide says, yeah. So what's next on the list?
Well, let's dive into the Condictio turpem vel inestam causam.
Okay.
It's a bit of a mouthful, I know, but it essentially means recovery because of an immoral or unjust cause. Think of it as the no rewards for bad behavior action.
Okay, I like that. No rewards for bad behavior action. So it applies to those situations where someone gains something through, through shady dealings or illegal activities.
Exactly. Imagine, you pour money into a business venture that turns out to be a front for illegal operations.
Oh,
You've suffered a loss, and the people behind the scheme have been enriched at your expense. The Condictio of turpem vet inestem kazam could potentially help you, get your money back.
so it's like hitting the endo button on a bad decision.
Yeah.
But with legal backing this time, are there any limitations or exceptions to this action?
There is an important caveat, the part delictum rule.
Okay.
It basically means you can't benefit from your own wrongdoing.
Okay.
If you willingly participated in an illegal scheme knowing it was shady, the court might not be so quick to help you recover your losses.
So ignorance is bliss in those situations.
Not necessarily. While the court might be more sympathetic if you were genuinely unaware of the illegal nature of the deal, the key is whether a reasonable person in your position would have known or suspected something was amiss.
So it's not just about claiming ignorance. It's about whether your ignorance was excusable.
Exactly. The court will carefully examine the circumstances to determine whether you were truly a victim or a willing participant
Okay.
in the wrongdoing.
Are there any situations where the par delictum rule might be relaxed, even if the plaintiff was involved in the shady deal?
Yes, the courts have the discretion to relax the rule, in the interest of fairness. They'll consider the specific facts of the case and weigh the various factors involved. The study guide actually mentions the Jajpai case as a prime example where the court exercised this discretion. It demonstrates that there's some flexibility in how the par delictum rule is applied.
So it's not a hard and fast rule.
Right.
There's room for nuance and consideration of the unique circumstances of each case.
Absolutely. The law aims to strike a balance between upholding legal principles and achieving just outcomes.
Okay. What other enrichment actions should we explore? The study guide lists a few more.
Let's talk about the Condictio causa data causa non secuta, which basically means the reason for the performance has failed. It addresses situations where the original, reason for a transfer or payment no longer exists.
Give me a real world example. I'm a big fan of those.
Imagine you make a down payment on a house with the understanding that the sale will be finalized on a certain date, but then the seller backs out of the deal at the last minute. The reason for your payment, the purchase of the house, has failed to materialize.
So the cause of the reason is gone, and you're left holding the bag.
Exactly. In this scenario, the Condictio causa data causa non secuta provides a legal avenue to potentially reclaim your down payment. It ensures that you're not left out of pocket when circumstances change and the original basis for the payment disappears.
Okay, that makes sense. What about that conditio sine causa specialis we briefly touched among earlier? The study guide refers to it as the catch-all enrichment action.
That's right. It's the miscellaneous drawer of enrichment actions,
Okay.
covering those situations that don't neatly fit into the other categories.
So it's like the none of the above option on a multiple choice test.
Exactly. One classic example is the recovery of property from a bona fide possessor, someone who possesses something they don't own but does so in good faith, believing they have a legitimate right to it.
Okay, so let's say I buy a vintage watch from a reputable dealer, completely unaware that it was actually stolen years ago. I'm a bona fide possessor. I have the watch, but I don't have legal ownership. What happens then?
Well, if the true owner comes forward, they have the right to reclaim their property. But you, the bona fide possessor, have suffered a loss. You paid for the watch, and now it's gone. The Condictio sine causa specialis can help you recover your money and even the person who sold it to you.
So even though the seller might not have known the watch was stolen, they were still enriched at my expense, and I can seek compensation. It seems like these enrichment actions are all about restoring fairness, ensuring that no one benefits unjustly from another person's loss.
That's the underlying principle driving this entire area of law. It's about correcting imbalances and making things right.
Okay, we've covered a lot of ground with estoppel and enrichment.
We have.
From mistaken payments to shady deals and everything in between, we've explored how these legal concepts work to uphold fairness and prevent unjust enrichment. I feel like I could ace a law exam right now.
Don't get too confident. Law exams are notoriously tricky,
That's true.
but you've definitely gained a solid understanding of these concepts.
All right. Before we wrap up, the study guide leaves us with a provocative thought.
Okay.
It poses the question of whether South African law should adopt a more general enrichment action
Yeah.
rather than relying on these specific categories. What do you think about that?
It's a fascinating idea. A general enrichment action could potentially simplify the law and make it easier to apply, but it could also lead to a flood of claims and make it harder to predict outcomes. It's a complex issue with no easy answers.
It's definitely something to ponder. It highlights the fact that law is a dynamic field,
Yes.
constantly evolving to meet the challenges of a changing world.
And that's what makes it so fascinating.
Okay, that's a wrap on our deep dive into estoppel and enrichment in South African law. We've explored these concepts from their historical roots to their modern day applications, breaking down complex legal principles into digestible bites. Hopefully, you've gained a newfound appreciation for how these concepts work to ensure fairness and balance in the legal system. Keep those legal brains buzzing.